Thank you, Agent Hansen. Your Honor, I have no further questions.
Mr. Hansen, do you have questions of the witness?
I'd like to seek counsel for a moment.
You may.
Question.
You may.
Now,
you may.
Until I seek more counsel. How do you have first-hand knowledge that that fingerprint in Florida is associated with any prints that were taken from me in the District of Nebraska?
Sir, the prints from Florida were part of an investigation, and there was evidence tied to this investigation. The fingerprints, or excuse me, the evidence was then sent to our National Forensics Lab for the IRS in Chicago, Illinois, where the fingerprints were analyzed by our forensic unit. The prints did come back to Mr. Paul John Hansen with the FBI number I mentioned earlier. And that's how I know we have the correct individual.
I'd like to see counsel.
You may.
One more question
you may.
before I seek more counsel. What was the evidence associated with the fingerprint from Florida?
Objection, relevance.
Overruled. He knows.
Your Honor, if I may look at the notes from the report.
You may.
Thank you. In a report dated August 26, 2014, from the Criminal Investigation National Forensic Laboratory of the Internal Revenue Service, there was one white envelope addressed to Mr. Mark Birnbaum. That last name is spelled B-I-R-N-B-A-U-M. There was one document inside the envelope noted as page 2 of 9 with the name warning. And there was another item. It was a document listed as page 7 of 9, which is a legal description of property, continued. And all three items had at least one fingerprint that was associated with the FBI number, as stated earlier.
You have further questions?
Yes, I'd like to seek counsel first.
You may.
Do you have any evidence that anything associated with the fingerprints in Florida have been verified in an open court of record?
I do not know whether those prints have been verified in an open court of record.
I'd like to seek counsel.
You may.
I need about 5 minutes because I left my glasses at home, but I can read looking through a little hole. It might just be a couple minutes.
Try these.
Oh. I normally
See if they work.
Yeah. Perfect. I'll take.
All right. Well, I want them back though. All right.
Thank you. I'm going to seek counsel now.
You may.
question. Where is the person that has the first-hand knowledge of the evidence in the District of Florida?
The person who wrote the report is from Chicago, Illinois, and in Illinois he works for the forensic lab. I believe that's the answer you're looking for. The case agents for this particular item, the investigation, they are in Pensacola, Florida.
The name, please?
The name is Special Agent Scott Schneider. Last name is spelled Schneider, I believe. The individual in Chicago, did you want that person's name?
Yes.
I'm going to look at the report as signed by the individual. That individual's name is James M. Snaduff. The last name is spelled Snaidauf. He has the acronym CLPE behind his name, and he has a title listed as Fingerprint Specialist.
I wish to see counsel again.
You may.
Are you aware of the best evidence rule?
I am not.
What is the reason that you don't have the person to testify today with the first-hand knowledge of the evidence that you're trying to present in relationship to fingerprints in the Florida district?
Mr. Hansen, that's not a question to the witness. That's a matter of argument that you may have in responding to the United States Attorney who is representing the government in this case. This witness does not control that.
Has the witness been told why the person with the first-hand knowledge has not been brought to Omaha today?
No, sir.
Did the witness ever ask if that witness could be brought to Omaha today?
No, sir.
I'd like to see counsel again.
You may.
I'd like to reserve, if need be, the witness to return to the witness stand, but I believe this is all the questions at this time.
Further questions?
No, sir.
All right. Then you may stand down.
Thank you, Your Honor.
All right. Do you have further evidence?
No, Your Honor.
All right. Do you have evidence you wish to present, Mr. Hansen?
I'd like to see counsel.
You may.
I've opted not to put any evidence in at this time.
Very well. Then I'll hear either side with respect to the issue of identity.
Me, Your Honor?
First, you got the burden.
Your Honor, I think I've carried my burden. The agent has provided evidence corroborating that the individual who was booked by the U.S. Marshals under the name Paul John Hansen had an FBI number associated with the fingerprints, which was identical to a Paul John Hansen out of the Northern District of Florida, and that particular FBI number was associated with a fingerprint out of that Northern District of Florida. Moreover, Your Honor, when we had the hearing on this matter last week, the individual essentially conceded that he was the Paul John Hansen who was named in the indictment in Florida. So I think by way of admission and by way of testimony from agency like the identity issue is resolves itself in our favor, Your Honor. Thank you.
Mr. Hansen.
I'd like to address the last part. He said that in the preceding hearing that I conceded that I was the person of the indictment, and if the court would review the record, I emphatically stated that I have no evidence that I am the person in the indictment, and that I required that they would prove that in all the elements necessary in its entirety.
As I recall, Mr. Hansen, you had indicated you stated your name was Paul John Hansen, but not that you were the person named in the indictment. So
that I had no knowledge if I was the person named in the indictment. That's correct.
All right.
Now I do have the challenge that I have here, as you've heard in the questioning, is first-hand witness. Historically, first-hand witness has been required in all common law proceedings. There is no evidence in the record that I am a U.S. person and waived any of the common law protections. And he did testify that he knew of a witness in in Florida and Chicago. He testified that well, the evidence has shown that those witnesses have not been procured here by the moving party. Therefore, I've asked for the best evidence to be brought forward. They've refused to do that by only bringing hearsay in. And if the witnesses did exist, they could be brought in, and they chose not to bring them in. It creates a great doubt on that evidence, and any court that uses evidence that is challenged, that's not supported by first-hand testimony and not verified in open court, is certainly questionable evidence. They're disturbing my life. As I sit here, my property is being stolen, very likely at home. My reputation is being destroyed. I was arrested at gunpoint. I had guns aimed at my face in front of my neighbors, my SWAT team, and they're going to do all this without bringing in first-hand evidence to follow due process and prosecution. So I end my argument there.
All right. These being preliminary proceedings, the court is well aware that the formal rules of evidence do not apply in that respect, and hearsay is admissible in these proceedings, and I find there's sufficient information to find that the defendant now before the court is the Paul John Hansen that's named in the indictment in the Northern District of Florida, and he'll be held to answer in the Northern District of Florida on the charges set forth in the indictment. Pending that, position of the government had moved for detention. I have taken judicial notice of the pretrial services report, filing number 3 in this matter. Mr. Hansen, you've been provided a copy of that, is that correct?
I don't know for sure.
I gave you a copy of your previous
All right,
report.
give him another copy right now. If you have another copy,
Thank you.
so that, all right. Do you have anything further than the pretrial services report, Mr. Franklin?
No, Your Honor.
Very well. I'll give you a moment to review that, Mr. Hansen, and then you can present such evidence as you wish with regard to the matter of detention.
Yes, I did want to inform the court that I did prosecute a case. I believe I mailed it on Friday as I moving as a prosecutor against the witness that just testified. And I prosecuting a court in this same federal courthouse room right here, ideally to where the witness was going to be called to produce evidence of a true verified indictment established against me, and also to produce evidence that the warrant was executed within the exclusive legislative authority that ultimately the warrant came from, pursuant to Article 1, Section 8 of the U.S. Constitution, which I would like the court to take jurisdiction of, not now, in the future. So I believe that court of record proceeding is one of right, and it ought to precede any hearing in this court action here. I believe this is this a legislative court, or is this an Article 3 constitutional court?
This is an Article 3 court, the United States District Court for the District of Nebraska.
Okay.
I'll give you such time as if you need to review or anything else.
Yeah.
And your request to defer this to some other proceeding is denied.
Yeah. Yes. Yes.
Mr. Hansen?
Ready?
Go ahead.
And could you rephrase exactly what you wish from me?
Well, I just need to hear you on the government's motion for detention pending your transfer to the Northern District of Florida.
Okay. First off, I want to establish that there's no reason to believe that there's any risk of flight. No reason at all. I'll list those reasons a little bit later. I'm going to move to the danger to the community. My entire history, there's no violence. No violence at all. I'm 56 years old. I'm single. I don't drink. I don't smoke. I smoked a half a cigarette my entire life. I've never done any drugs. I haven't missed church in close to 30 years. Taught Sunday school for many of those years. People refer to me as highly knowledgeable in the scriptures and delight listening to my application of those scriptures to life. And just a good, I like to refer to me as a good founding father type person of the nation. I really love to study the minds of the founding fathers, and I try to replicate them. And when I was arrested, I didn't lift a finger, no argument, completely courteous. Even though they surrounded my house with a SWAT team and aimed guns in my faces, I didn't become angry or nothing. Completely understood that the guys doing that action are just doing their job and they don't know what to expect. So I've never ran from anybody in the police department. I've always, as far as the failure to appear on my record, every one of those is associated with my challenging the court to produce a verified Fourth Amendment. I give the court judicial notice on the Fourth Amendment eventually when I realized how to do it. And when I started doing that, they dismissed the failure to appears. But I always challenge, produce the Fourth Amendment oath or affirmation in support of the warrant. I was contacted by one of the judges, and he said, "Mr. Hansen, I understand that what you're doing is you're trying to restore the constitutional premise of the Fourth Amendment, and you're forcing them to actually procure proper elements on the record to where you're required to appear." So that's the reason for the failure to appears. I was simply trying to protect society by establishing a system, a continued system that they're to follow by adhering to the Fourth Amendment of the United States Constitution, by having all the elements of verified evidence and so forth in the record before they can issue a warrant. And I've lived in Omaha. I lived in Nebraska all my life. I've left the country one time. I think I went into Canada for 2 days. And I've lived in Omaha for, I think close to 15 or 20 years. It's hard to remember. But and my other living was only 80 miles north of here on a farm. Got a strong work ethic. I was raised on a farm. When I was 16, 17 years old, I was feeding 1,500 cattle by myself and caring for all the health issues of a cattle feedlot operation. Many of the veterinarians and my father said they were very impressed with my ability to take responsibility and do a man's work, and I've done that ever since. I've worked all my life. Never a day have I not worked. I have family in the area. I have a mother living 80 miles north, brother living, two other brothers living about the same distance away, and two sisters living relatively close to Omaha, and one in Omaha actually. Let's see. I noticed the report said that I went to Canada 3 to 5 years ago, but that was actually almost 35 years ago that I went to Canada for those couple days on a motorcycle trip. Oh, let's see. I have businesses in Omaha, as you can see. Currently I have a roof torn off one of my houses that I'm not done with. I definitely want to get back to that and finish it. I want to conduct business in Omaha. Of course, I do repairs on my homes, and I do collect rent. I have nobody to do that for me. When I'm in jail, it doesn't happen. So I'm basically impoverished for part of that reason. And I am. The reason I did not go to Florida on the subpoena is that I emailed them, I wrote them a letter, I'm pretty sure I tried to call them, and I told them, and I even believe that I sent one of the letters by a notary presentment to the clerk of the court, and I clearly said on the document that I am working in Omaha and that there is no compelling law on this document that would notify me of a duty to appear. Only the word summons is on there. And I also notified them that there is no notice on the document that if I did not appear, that such and such consequences would be established. So I told them, I said, it appears to me like this is just an invitation to come to Florida. There's no compelling law in there. No compelling law at all. Not a single word on there of a reference to a statute at large, or a U.S. code, or a Florida law. And I was very shocked when I didn't see that. So I said, just if you guys want to email me the statute of law that you're relying upon, or even the codified law, that I would be, if it clearly gives me a duty, then I'll be a good neighbor, and I'll be down there right away. But they wouldn't do it, and I said, well, if you guys, through the emails, I said, if you guys don't want to do it, you're actually admitting that you don't have anything in written law to place a duty on me to appear there. And I said, when you do that, I'll certainly appear. So I believe that the court, looking at me today and listening to my words, probably can perceive that I have studied law in the past, and which is the reason I got involved with CSE Ministries in Florida. I've never been down there, but they were seeking a trustee to manage the church property down there, and Ken Hovind couldn't find nobody to do it, or the church itself couldn't find anybody to do it. Ken Hovind was the main employee of that trust operation, and I offered to do it, so I'm not even paid to do it. So I'm in quite a pickle for something that I'm not even paid to do. But there is an indictment now, and I certainly want to be a good neighbor, and I think it's a sin not to obey good lawful orders. And like I said, that's what I asked them to do, is give me a good basis of law for me to come down, and I'll certainly obey it. But if the court tells me to go down there for any reason, at any time, I'll be down there.
Well, the court must look at several matters for the issue of detention. First, whether a danger to the community, and that has to be established by clear and convincing evidence that the defendant is a danger to the community. In financial cases, the court has in the past found a person to be a danger to the community by a continuation of fraudulent activities. In this case, I suppose it could be said that the defendant to be considered a danger to the community to the extent of filing false liens in this matter. against the property and titles of individuals and agents in this matter. And to that extent, he could be considered a danger to the community, but I don't find that there is clear and convincing evidence that there would be no condition or combination of conditions which would reasonably assure the safety of the community in the event he was to be released.
I agree.
According,
No liens at all. I won't touch any of that.
Accordingly, and the defendant should be well aware that in the situation where if he were to do such certain things, that there are statutes, federal statutes involved that make such activities criminal in nature and have such consequences that I'm sure he's well aware of in this matter. And so I do not find that he's a danger to the community within the issue of the matter of detention. The other matter is that of flight risk. And flight risk is not simply that we can't find him. It's a question of whether or not he will obey court orders and appear when he's ordered to appear. The indictment itself shows itself that the defendant there's probable cause. An indictment constitutes probable cause that the grand jury in the Northern District of Florida found that the defendant was commanded to appear in the Northern District of Florida and did not appear, which resulted in the charges in counts 5 and 6 of this matter, that he has not appeared. In this particular case, in listening to the defendant and saying that he challenges the court's authority all the time with regard to why he should do this and why he should do that, that the court, I find, that there is there is evidence to show that the defendant would not appear when ordered to appear as shown in the past. And so consequently I find that the defendant should be detained in the custody of the marshal and transported to the Northern District of Florida to answer to the charges in the indictment. With regard to the matter of identity, as I've already said, I find from the evidence that there is evidence that he is the person named in the indictment, together with the electronic duplicate of the warrant that's set forth in filing number 1 in this case. For those reasons...
I do have a question.
You may.
I notified them and asked them, please tell me, and just tell me where in written law that I'm required to appear. I don't understand if the word subpoena has any force and effect against me, and they would not answer, even though I sent them a letter by a notary presentment to have proof at any time in the future that I'm just asking, what law are you relying upon to have me that does not live in a U.S. district to show up in a U.S. court in Florida?
Well, Mr. Hansen, that gives me concern to say if I tell you to go to Florida, you're going to say, where's your authority, where's your law to do that?
No,
I'm not going to put Florida in that situation to say, well, is he coming down? Is he doing this? Do we have to send? They have sent their message in this matter.
I will give a promise to go down there.
Well,
I asked them, just give me notice of law, and I will appear. They refused to do that, but I will promise to appear.
Well,
I give my word.
That to me, that ship has sailed, and so consequently, you'll be detained in the custody of the marshal so that they can transfer you down there, and then you can convince a magistrate judge in the Northern District of Florida that you will abide by further orders from that court, and so consequently, that'll be the decision of the court. Counsel,
I have a question.
Yes?
How do I challenge that if the arrest took place in which the warrant has force and effect of law?
I'm not going to instruct you into the law, that is, or to provide you tutelage on these matters.
Can I seek counsel at this time to
You
give a reply to that?
you can seek counsel and so forth, but it's after the fact, and you can take such action as you feel to appeal if you necessary or whatever you need to do. But that's the order, my order of the court, and as such, you're remanded to the custody of the marshal for transfer to the Northern District of Florida. We stand in recess.
Thank you.